Bill 113 into the record, and then we read communication 393.68, which is an amendment. We read that into the record. There was a motion and a second, but we have not gone into discussion on this amendment as yet. Today we have all of the council members here except Mr. Kern, who was here earlier, but he had to leave. He was getting really sick. So we'll keep you posted about that if he can return, or if he does return. Mr. Yoshimoto, do we need to take a roll call this morning? No, we're just, okay. All right. Then I'll just resume discussion. Ms. Willie, would you like to lead off?
I want to remind everyone that I did this bill as a companion piece to an ad hoc that I'm not going to discuss the contents of, but that will come up. And that I was trying to sort of draw the line. How do we do legislation that holds, stand still, hold in place, but at the same time close the door on further spread of GMOs while these discussions can be carried on? So I did this in a way that I don't feel, okay, we could have massaged this and filled it out and done sort of really work through some of the issues, or whether to have administrative remedies or how to do something. And I'm really trying to leave some of those questions for the ad hoc. To the extent that I did these amendments that are in 393.68, on the advice of attorneys from one of our senators' staff, is just really focusing on why this is such a local issue and a home rule issue, and why agricultural policy, where we're dealing here, basically protecting the property rights of non-GMO farmers and neighboring property owners, and public property rights, such as in terms of water. So the bill does not fulfill all of that vision. It really is a direction, a step in that direction. I am committed to doing the ad hoc committee. I felt that in terms of some of the fears that were addressed, that I personally didn't believe were significant. I mean, or were maybe realistic, but they were real. So I did put in, one, the provision on registration, so that in terms of registration, there could be some withholding of information to the extent that it would be something that someone would be afraid and might not put in the most accurate information. And I really just followed the law here, is saying what's already in the state law under 92F-13. And what I wrote here is could withhold such information as the name of the registrant and the exact location where a GMO crop is. I did add into registration putting in the council district, so it could be generalized. And then I also put in the emergency exemption, which, I understand some people would see as a loophole, but I just felt it was something that is a fear, sort of the sky is falling and what do we do? Provision while the ad hoc committee's moving on. It at least gave some context for what is a fear of those who, suddenly there was a banana bungee epidemic taking over, and that one could address it. In my view, let me just say, GMOs is a tool, but I consider it like the 30% tool. The value of the crop will drop 70%. The number of growers will drop 70%. You're really using, in terms of the marketing and the acceptance around the world will drop by 70%. So at what point does one really do that? Certainly you would not want to do it where you would be contaminating somebody else, or potentially if there was another available solution. And then lastly, in terms of this change, I did, in working with initially both Mitch Roth and then Kathy Garson, aligning the bill up more the way it is for taro and coffee, and also other municipal restricting GMO bills around the country, so that you wouldn't have sort of a civil thing on one side on this bill and then this petty misdemeanor one for coffee and taro. And again, we can look at those in terms of the ad hoc committee. You know, there are still some questions. Well, really, the injunctive provision is in all three, and, you know, really should one have it? The court could always find that some provision isn't possible and move on. So I'm just asking you, this is like a basic skeletal structure. We can build on it. At the same time, again, trying to close the door so we can have this discussion without worrying suddenly there's going to be a further spread of GMOs. And at the same time, last thing, basically this doesn't eliminate jobs. It isn't a big thing like Kauai. We don't want to get there. So I ask for your support. I know it's not the greatest. I've tried to work it through all the discussions, in particular the discussions that all of you have brought up, and move forward. As Mitch Roth said, is you make a policy statement. That's the direction. Stewardship is where we're going, and move that forward.
Ms. Woolley, I can come back to you while we're discussing the amendment, but I'm going to take any other comments at this time. Would anyone else like to comment on the amendment? Ms. Ford? We're on communication 393.68.
Yes. The only section I'm still having a problem with is the emergency exemption, because I think it dramatically weakens the bill. I do think it's a loophole. And the reason I think it's a loophole is, look at number 3. All available measures will be undertaken to ensure that non-genetically engineered crops and plants, as well as neighboring properties and any water sources, will be protected from contamination or any other potentially adverse effects that may be caused by the genetically engineered organism or associated pesticides, okay? All available measures. Right now, people could take all available measures, but they're not. They're not, they don't want to do the buffers, they don't want to do anything, and still, in Kona, I've got a farmer in Kona with organic papayas. 170 trees he had to cut down because 30% of them got contaminated. Now, did they get contaminated from Puna? Did the pollen fly over here? Did it, you know, we heard about the 1% drift rate. 30% of your crop is contaminated is not a 1% drift rate. So when I look at the emergency exemption, this is exactly what I think should be in the ad hoc committee for discussion. The other thing is, you've referred throughout your document to plants and crops. Does that mean we're not going to deal with the genetically modified animals that may or may not be here, or may not come onto our island? I'm concerned about that. Also, you talk about pestilence. What about animal pestilence? What about, and then you talk about pesticides. Well, there's pesticides. That's kind of a generic term. Most people think it's regarding insecticide, and it can be. But there's also fungicides and herbicides that you put into these plants genetically, and they're all just as dangerous. So I am concerned that the animals are not being covered, that only plants and crops are being covered. Fungicides and herbicides are not being considered here, and this exemption looks to me as if we're going to have a giant problem, a giant loophole. I think the ad hoc committee should take this one section that should be just stripped out of your amendment and send that over to the ad hoc committee and let them deal with it. I think that they can appropriately address these issues and maybe tighten up this language. It's not possible to protect non-GMO crops or plants from drift. You can't do it if it's out in the open air. I'm going to yield.
Mr. Kanuha?
No, I personally support Margaret's amendment. In the terms of the animals part, I mean, the title of the bill is restriction of genetically, or in this amendment, engineered crops and plants. I personally like that. It makes it simpler, it makes it more relating to the actual bill itself. So, in terms of the putting things in the ad hoc committee, a lot of this stuff could have been in the ad hoc committee. This whole bill could have been in the ad hoc committee, if, you know, but I appreciate what Margaret has done, listened to everybody on this council, and kind of worked with that, gone through Corporation Council and the different attorneys that we have within the county, and made a generally better bill. So I appreciate that, and I'll be supporting your amendment if you keep it. Thank you.
Any other discussion on the amendment? Okay. Seeing none. Madam Clerk, roll call vote on amending Bill 113 with the contents of Communication 393.68.
Yes, amendment to Bill 113, Draft 2, with the contents of Communication 393.68. Ms. Ford. Mr. Lagan.
No.
Mr. Kanuha.
Aye.
Mr. Kern.
He's excused.
Mr. Onishi. Ms. Poindexter?
Aye.
Ms. Willie?
Aye.
Mr. Ishimoto?
Aye.
Ms. Ford? Kanalua? Thank you. Chair Yoff?
Aye.
Chair Yoff, you have 7 ayes, 1 no, 1 absent.
Thank you. Bill 113 is amended with the contents of Communication 393.68. Now we're back to the main motion, which is Bill 113 as amended. Mr. Onishi.
Thank you, Madam Chair. Mr. Ishida, can you please come up?
Mike.
Can you introduce yourself?
Lincoln Ishida, Corporation Counsel. Good afternoon, everyone.
Okay, I just had a couple questions. I do have an amendment here, and it's about, you know, possible exempting the universities and the government agencies in the exemption part.
Tell me which communication this is, because I'm following this by number.
Communication 393.67, but...
Point of order, we're not
discussing that communication.
Amendment, huh? I think we're...
No, but I'm just going to ask him about his opinion about...
I think you would need to make a motion to amend.
No, but right now the bill restricts... Right now, the original bill, this amended bill, restricts universities and government agencies.
Well, maybe you should ask that question.
Okay.
Ask it about the bill.
Let me. How's that question then? Okay.
Or do you want to ask Mr. Ishida?
Yes, that's what I'm.
What are you asking?
Well, Mr. Onishi and I, during the lunch, right when we got back from the lunch break, he had asked me, I'm just going to discuss what we, the question that you posed to me, which was whether, because there's been so much talk about federal and state preemption, and primarily when we talk about, let's say, research that's done by the University of Hawaii, the state system, how does this bill affect them? Whether does preemption come into play where, notwithstanding whatever this council passes, can they continue to do their research or what have you? And the short answer is no. If there is a for lack of a better term, GMO ban that includes a ban on research, open air or otherwise, it applies to the state. Okay? The only time that preemption renders our ordinances inapplicable is if then the state passes a law that is in conflict with a county law or ordinance. Okay? So in the absence of state legislation in the area, the county is legislating in that area. So as currently written, if research is not included as one of the permissible activities, the present draft of the bill would effectively halt that. Preemption is not even an issue, will not become an issue until such time that the state legislates. In other words, just thinking ahead, if the concern for the state folks or the research folks is they want they want to continue their research in light of this bill, which say it passes, they would then rely on the state to have to legislate in the area to effectively preempt the county at that point. Doesn't matter, under preemption, doesn't matter who came first. It's not really a timing issue as much as a jurisdictional one.
Okay, and then so would this also be in relationship to the federal government?
Similarly, yes. Yeah. Preemption applies similarly to federal questions as well. Okay, so like or jurisdictional areas, I should say.
So, for example, like PBARC, right, with the USDA, and they're like right now, okay, or if they want to, okay, if this bill passes, then the federal government would have to do some kind of law on their side to exempt them.
Well, I'm not familiar with the particulars of the situation that you raised, but generally, whenever you talk about preemption, generally, it's a conflict of laws question. Okay, preemption is a conflict of laws question, which means that there must be an existing authority of general law that conflicts with the local ordinance which it seeks to supplant it. That's the general theory behind preemption.
Okay, and it's so like on my first term, I guess the feds wanted to do biocontrol on the strawberry guava, and the council at that time, I think, passed like a resolution discouraging the USDA, I guess, or the state agency not to use that, but they still did, I guess, on the state lands. So,
Mr. Onishi, I don't have an independent recollection of that particular debate or issue, but did you say that it was a resolution that was passed?
Yeah, I think it was a resolution.
By the council.
Right.
And, I mean, not having an independent recollection, but just having you say that pretty much makes sense because of preemption, you couldn't pass an ordinance. You would have to pass a resolution simply saying, we disagree. I mean, I don't know the particulars, so I don't want to really...
Okay, well, I'll go send that email to you later on. Yeah,
okay. Appreciate that.
Okay, thank you very much. Thank you, Madam Chair.
To correct them.
Ms. Willie, Mr. Ilagan would like to speak, but I'm going to give you an opportunity, if you can do it quickly, to just clear up whatever misinformation you feel you need.
It's just that because of that type of concern is the reason that I put open air. They are not doing open air research. This means, in fact, as long as it's enclosed, and in fact it says greenhouse, or it's very enclosure, and so it's only there's no restriction on research and development unless they were to begin doing it open air, where it would the same issues would come up. So I just want to clarify: there's nothing stopping research, and we want research to be in a controlled environment because, anyway, the obvious reason. So I just want to clarify that was the key to the changes in my bill from 79 to 113.
Okay, thank you. Mr. Ilagan?
I just want. Thank you, Madam Chair. I just wanted to, Mr. Ishida. I just want your final legal opinion on what Councilmember Willie just mentioned. Because I'm talking to two lawyers right now.
What's your question?
She just stated that it does not, it doesn't restrict. So is that correct?
I don't know. I don't know what I don't have independent knowledge what the UH is doing for the extent of their research.
So currently we're not clear.
Well, I'm not clear. I wasn't given that information.
Okay. How would we go about in finding that out?
I don't know, maybe you can call and ask, or, you know, ask them. I mean, I think UH representatives have come here, but I surmise that Ms. Willie has done her due diligence and has investigated those, that issue. So perhaps you could, that's really not a legal question as much as more a factual question of what's occurring.
Okay. So there's no legal portion on this part?
Well, whether what they're doing is not really a legal question, it's a factual inquiry.
Okay.
I don't have that information.
Sounds good. Thank you.
Can you stay there real quick? Please, I'm sorry.
You might as well stay there, Mr. Ishida.
I'm trying to digest this awesome lunch that
I know that. Believe me, we are trying to also.
Ms. Poindexter.
Okay. I think what Councilmember Onishi was speaking of with the previous council was a resolution versus a bill. So a resolution doesn't have the power to tell the feds, hey, you cannot do that. It's just a resolution. It doesn't hold. It's just like we asking, please don't do that, you know, versus a bill that says you're not going to do that. Am I correct?
You are.
Thank you.
Ms. Ford?
Thank you. Let me read the prohibition that Margaret wrote into her bill. No person shall knowingly engage in the open air cultivation, propagation, development, or testing of genetically engineered crops or plants. She specifically says open air. So if they're doing it in a laboratory, they can do it. Now, I personally have a problem having this done in a greenhouse because I have a greenhouse, I have shade houses, and they are not capable of holding everything in, which is why I've always recommended a biosafety level 3. I won't go into that, but that's the reason I was recommending that. We just don't want, according to this bill, we do not want an open air cultivation. That's the difference. There is nothing that in this bill that precludes research by UH or anybody else in a closed environment. Nothing. Thank you.
Mr. Onishi?
Yeah, and I just got it clarified from Ms. Willie is that all they need to do is just register, correct?
Oh, say that again.
That what you mentioned to me was that all they need to do is just register.
Yes.
Correct.
Yes.
Yeah. Okay. So that's good.
So, and
But
that's
just
so
one
we
thing.
have the knowledge of what is happening, and we're doing an ad hoc. We want the most knowledge. We want to be the most informed possible.
The ad hoc is okay,
Yeah.
but I just wanted to clarify to make sure that that's all they need to follow.
Yes.
Okay. And then, Mr. Shida, one last thing. Sorry about that. No, we did get, or we did see a letter from the AG's office, and in your interpretation, they're not taking a stand. Is that correct?
I think it's not just my interpretation, but anybody's interpretation who reads it. They were pretty unequivocal that it was not their intention to offer any opinions.
Right.
Just for the council members' information, under the statutory scheme in the state of Hawaii, under the HRS provisions dealing with the Attorney General, they are obliged, required, mandated by law to provide legal opinions to state agencies, officers, directors. But with respect to other counties, well, other government agencies, which for purposes of HRS primarily means the 4 counties, there's no such requirement, but rather their responsibility, if you want to call it that, is one of election. They can elect to advise or not, and in this case, they have exercised that option.
Okay, thank you. And then just another fast comment was that I guess the previous council, what they should have done was just make a bill, right, instead of a resolution encouraging the federal government not to use biocontrol. Right, thank you.
Council members, are there any other comments? Nope. Seeing none, Madam Clerk, I believe we're ready to take the vote on Bill 113 as amended.
Bill 113, Draft 2 as amended. Ms. Ford.
As amended by communication number
393.68.
Sorry.
Thank you. Aye.
Thank you. Mr. Lagan.
No.
Mr. Kanuha. Mr. Onishi.
No.
Ms. Poindexter.
Aye.
Ms. Willie.
Aye.
Mr. Ishimoto.
Aye.
Mr. Kanuha.
Aye.
Chair Eoff.
Aye.
Chair Eoff, you have 6 ayes.
Thank you.
2 noes.
Bill 113. Bill 113 will move to council for second reading.
Move to adjourn.
November 6th. Moved by Mr. Yoshimoto, second by Ms. Ford to adjourn. All in favor?
Aye.
Meeting's adjourned. Thank you. Thank you all.